Please be seated, Vuyuswa.
All right, I see the CLRV is ready to go.
Thank you, Madam President, and may it please the Court. It is my privilege to address this chamber on behalf of victims in this case. The LRA was notorious for abduction. Families and communities were simply torn apart. Young and old were systematically abducted from their homes, their villages, and their schools. Some were kept for days or weeks, others for months and years. And many have never returned. Every day, parents of the missing still wait and hope for their children to come back home. As the evidence makes clear, life in the bush was hell on earth. Instead of holding books and pencils, children were made to hold guns and weapons, made to attack and kill their own people. Joseph Kony stole the childhood away from the children of northern Uganda. If you were female, you were subjected first to domestic servitude and forced marriage, where many suffered severe sexual abuse. Children were born in that context. In the case law of this court, they too are victims, and children born of war are among the clients that we represent. The LRA committed not only physical violations, but cultural norms were violated too. For example, through forced marriage, centuries-old practices around traditional courtship and dowries were discarded as Joseph Kony implemented his cruel regime. But beyond their immediate effects, these crimes have had a lasting impact on victims and their communities. Allow me to highlight two such aspects. The first is the impact on livelihood. Abduction robbed many victims of their education and their ambitions. As one returnee told me, quote, "By taking me into the bush, the rebels took my past, my present, and my future." When abductees escaped, the Ugandan government gave them amnesty, even though abducted children had nothing to be sorry for. Typically, returnees got an amnesty certificate, a blanket, and a jerry can. And if they were lucky, a handful of Ugandan shillings to restart their life. Rehabilitation centres such as Rakele in Lira and Gulu Support the Children organisation, or GUSCO for short, did exceptional work to receive and to counsel traumatised children, even as war continued to rage. However, up to now, many returnees have struggled to reintegrate and face challenges around mental health, substance abuse, and domestic violence. There is a saying in northern Uganda: the guns may be silent, but the conflict continues. The second aspect I wish to highlight is stigma. Many returnees live today with enduring stigmatization. Their ability to fully take part in community life is often blocked because they are labelled rebels, Coyne's wives, or those who belong in the bush. Social exclusion and discrimination is very common. Children who were born in captivity also endure stigma and harm that goes unseen. For example, a child born in captivity will typically not know their father's clan. As a result, they are unable to inherit land. Without land, you cannot grow or sell food. You cannot raise livestock, which limits them in many areas of their lives, like paying education fees and their ability to undergo traditional marriage. They are punished simply for being born. Madam President, Your Honours, the direct, the indirect, and the transgenerational harm caused by these crimes is grave. It shocks the conscience. In truth, my words are inadequate, as the harm caused by Joseph Coyne is quite literally beyond description. But in these proceedings, this harm must find description. And in the DCC, 25 of 39 counts relate to systemic crimes, almost 2/3. And the victims wish to convey certain views and concerns in relation to each main category. In relation to counts 25 and 26, namely the conscription and use of children, the victims welcome the broadened material scope of these charges, which now cover conscription into any part of the LRA, as opposed to just one brigade, like in the Ongwen case. Victims understandably felt a great degree of frustration at the narrow charges in Ongwen. This can now be addressed by holding Joseph Coyne responsible as leader. That children were conscripted by the LRA and used in hostilities is a matter of public record. The evidence is undeniable. As leader, Joseph Coyne bears criminal responsibility. Likewise, in relation to the SGBC counts, namely counts 15 to 24 and 27 to 39, the victims welcome the broadened material scope of these charges, which now cover conduct committed throughout the LRA. The counts relating to enslavement, sexual slavery, forced marriage, rape, torture, severe abuse and mistreatment, cruel treatment, forced pregnancy, and persecution are all entirely justified. These counts serve to capture the range of experiences that women and girls endured while in captivity. Age and gender were central to the discriminatory motives of Joseph Coyne when he issued his persecutory orders to abduct. During the Ongwen case, evidence of male-on-male sexual violence was brought to light by a victim's counsel. But such conduct has not been included in these proceedings. While understandably a taboo topic for both victims and perpetrators, male-on-male sexual violence sometimes did occur, and it is part of the overall story of the conflict that should be told. With regard to the Luala Girls' School attack, the victims welcome its inclusion as a standalone charge. This was one of the most notorious abduction incidents of the war, where over 70 young girls were stolen from their beds, beaten, marched all the way to Sudan, and distributed to LRA commanders. Some of the Luala girls even became forced wives to Joseph Kony himself. Indeed, the Luala attack is representative of the LRA's modus operandi in relation to women and girls more generally. The attack was part of a long-standing pattern where the LRA targeted schools in particular, even going back to the mid-1990s. For example, another notorious attack on St. Mary's College in Iboke in 1996, when dozens of girls were stolen from their dormitories. Many of them were too held captive in the bush for years. The terrible legacy of these attacks on Iboke, Luala, and other schools remain vivid in the memory of people across the north. To borrow the words of a Choli poet, Okot P. Batek, the LRA rebellion resulted in thousands of, quote, deserted homesteads. The LRA destroyed what Batek described as Peen Mabe, which translates as good surroundings. According to Batek, this concept means, quote, when things are normal, society thrives, facing and overcoming crisis. The violence directed by Joseph Kony shattered society. Normal life was not possible. The safety and social bonds normally provided in the homestead, in the village, and at school were ruined and replaced with trauma, fear, and displacement. Madam President, Your Honours, in relation to the exclusion of sexual slavery as a crime against humanity, the victims wish again to place on the record their regret that this crime has not been charged. In this regard, we have a specific request of the Chamber. Before making that request, let me say the following. In many ways, sexual slavery was the signature crime of the LRA. Women and girls were deprived of their liberty and subjected to acts of a sexual nature. Sexual slavery touched all areas of northern Uganda, from Arua in the west to Kotido in the east, from Soroti in the south to Kitgum in the north. Sexual slavery was committed on a widespread and systematic basis and pursuant to an organizational policy. In summary, the prosecution's view as expressed in filing 482 is that the crime of enslavement better captures such conduct and that any final judgment may be fragmented if sexual slavery as a crime against humanity is included. The victims fully respect and acknowledge that the prosecution has statutory discretion to bring the charges. However, in our respectful submission, the reasons offered for excluding sexual slavery as a crime against humanity are not convincing. I make 3 points in this regard. First, the net effect of this charging approach is to make sexual slavery as a crime against humanity redundant as a Rome Statute crime. The drafters never intended this. Second, sexual slavery and enslavement are distinct crimes protecting different interests. While both involve the exercise of ownership, sexual slavery requires the additional element of an act of a sexual nature. Third, charging sexual slavery as a war crime alone is, in our submission, inadequate. Sexual slavery under Article 7 and Article 8 differ in their contextual elements. One relates to armed conflict, while the other relates to attacks on the civilian population. These are different legal frameworks covering different contexts. As held in the Onwin Appeals judgment, differing contextual elements allows for the identification of different legal interests that are protected by each provision. And that's at paragraph 1656 of that judgment. The victims respectfully submit that the exclusion of sexual slavery under Article 7 in these proceedings creates a potential accountability gap that is unnecessary and avoidable. At this pre-trial stage, we are only concerned if there are substantial grounds to believe a crime is being committed. We are not yet concerned with the extent and the degree to which the suspect will be convicted. The Chamber will recall the previous litigation on this issue. In your decision of 12 December 2024, filing number 538, the Chamber held, quote, the exact legal qualification of any alleged criminal conduct can only be assessed following the disclosure of the prosecution's evidence and the subsequent presentation of the evidence. The Chamber further held that the matter could be assessed, quote, at an appropriate juncture. In my respectful submission, that juncture is now. There can be no doubt the crime of sexual slavery as a crime against humanity is established on the evidence. The core elements are present. The contextual elements are present. If your honours accept that sexual slavery under Article 8 has occurred, then it must follow that it occurred under Article 7 as well. The appropriate course of action, then, is for your honours to use your inherent powers to re-characterise the facts and confirm sexual slavery in a manner that reflects the manifest legal character of the material facts in this case. The correct result should therefore be the existing counts charging sexual slavery under Article 8, namely counts 27 and 36, should be confirmed to include sexual slavery under Article 7 as well. Doing so ensures a more complete understanding and characterization of the harm inflicted, both factually and legally. In my submission, additional or new counts are not necessary to grant this request, because the underlying factual conduct remains the same. And for the same reason, it's also not necessary to adjourn. In support of this view and interpretation, I wish to highlight a structural aspect of the existing sexual slavery counts. Notably, counts 27 and 36 each and already charge two separate modes of liability, namely Article 25(3)A and B, which are offered in the alternative. If it is permissible for a single count to include more than one legal characterization of the accused's conduct, it logically follows that it is also permissible for a single count to include more than one legal characterization of the material facts. The core purpose of this hearing and the confirmation decision is to assess the alleged conduct and to confirm charges with their appropriate legal characterization. Therefore, when confirming counts 27 and 36, the Chamber should confirm both sexual slavery as a war crime and as a crime against humanity. No prejudice arises by making or granting this request. This is a discrete legal issue, and the parties can make any relevant submissions in the course of this hearing. The issue can then form part of your Honour's decision on the merits, the confirmation decision. Finally, I wish to make a submission on the merits of holding these in absentia proceedings more generally. Everybody following this case is familiar with the peace versus justice debate in Uganda. In that debate, the views of local leaders are often given more of a platform than victims. Indeed, victims are often left out of that debate altogether. But when you do ask victims, when you go to the village, when you sit down and you talk with them, their view is clear. Our clients resolutely support the process of accountability against Joseph Kony, a man who caused untold death and suffering across 2 decades in northern Uganda and beyond. Regardless of tribe or clan, be they Acholi, Langi, Lukbara, Madi, Iteso, or Kuman, the people of northern Uganda ordinarily expect accountability for wrongdoing. Whether that is informal or formal, in a courtroom, or through a traditional ceremony like Matua Put or another form. Apology and reparation is essential. In this regard, I wish to quote the statement of Ms. Pamela Judith Angwech, Annex H to Defence Filing 583, at paragraph 12. And I quote, "In our culture, an apology is central. When a perpetrator is unapologetic, they remain tied to the victims, who remain with their pain." End quote. The victims wish to highlight that Joseph Kony has never sought to apologize to the people of northern Uganda, and he has never offered to make reparation. The essential ingredients for traditional justice are absent, just like Joseph Kony is today. possibility for traditional mechanisms were even included in the draft Juba peace agreement in 2008. But Kony rejected the entire agreement and returned to war. He has always been running away from responsibility. Ultimately, when wrongdoing amounts to grave international crimes, the Rome Statute may legitimately provide accountability and justice for victims. Not only are these proceedings legally justified, they are morally justified. For victims, this hearing is not a token gesture. It is extremely important. Victims deserve and are entitled to take part in this process. They know and understand a full trial can only happen with Joseph Kony present. But no matter what anybody says, either inside this courtroom or outside of it, a confirmation decision will bring an important measure of accountability for victims. But more importantly, confirming charges will mean that after 20 years of waiting, victim testimonies will have been heard, will have been listened to, and acknowledged by this international criminal court. On behalf of the victims, I thank you for your attention.
Thank you very much. I think we have time to go directly to the defense submissions on the merit.
Thank you, Your Honour, and just good morning. I'm anticipating that this is a 90-minute session and that we will finish at 1 o'clock. I also anticipate that these submissions will take about 40 minutes, and so we should comfortably finish before the lunch break. In other housekeeping matters, I will remain entirely in open session. Nobody needs to worry about what I'm going to say during the course of the next 40 minutes. And secondly, you should all have received what I think is headed a list of authorities. It's actually a list of decisions and authorities that I will refer to during the course of these submissions. I will not be giving you long reference numbers either to ERNs or filings, and the authorities and filings are sequentially listed helpfully for you so that you can check me as I go along. Lastly, I omitted this morning to inform you of the changes in the defence team. The lady who was sitting next to me but is now behind me is Yvonne McDermott, who glories under the titles of both Professor and Master. And the case manager this morning is Eva Daniel. I should say, for the benefit of the watching public, because it has caused some consternation, that the gentleman at the back of the court is a security guard. He's not a member of the defence team, and he certainly isn't Joseph Kony. Anyway, on to the substance of these
Thank you,
submissions.
Council. May I have one moment, please? Council, just a moment. I'm trying to ascertain whether we received the list. Okay. Right then.
Okay.
We have it
I
in the
hope
bundle.
everything's in order with you.
Yes. All right. Thank you.
In my remarks yesterday, I spoke about the difficulties in determining the best interests of a person who cannot be consulted. Today, I will address the limitations arising from those difficulties in terms of the submissions that can be advanced on behalf of the suspect, and propose a specific course of action we say must now be taken by the pre-trial chamber to ensure the suspect's rights are fully preserved. When the prosecution first proposed an in absentia confirmation hearing in this case, it put forward a number of purported justifications, including to air the evidence, to give the victims a chance to speak, and to increase public awareness. We submit that these have been met to the extent that they can be through this hearing itself and the publicity and preparations leading up to it. None of these objectives will be further advanced by the issuance of a confirmation decision. This being the case, we submit that at the end of this hearing, this Honourable Chamber should issue a conditional stay of proceedings and discharge my mandate as counsel appointed to represent the interests of Joseph Kony. I acknowledge that this may, at first glance...
Council, one moment, please. I heard a... Yes, thank you. Council, I'm hearing a voice asking me if for the Acholi booth, if you can possibly slow down. I didn't think you were going terribly fast.
I didn't think I could speak any slower, frankly, but I'll do my very best.
Perhaps a pause between sentences.
Certainly. I acknowledge that this may appear at first glance to be a startling outcome. But it is much less startling when we recognise, as the statute requires, that these in absentia proceedings must halt before trial preparations commence under Part 6 of the statute. Whether that happens before or after the confirmation decision, there will be a stay of proceedings. For the reasons I will explain, we submit that a stay prior to the confirmation decision is the only way to preserve the rights of the suspect and to ensure fairness of any trial proceedings that might ensue. Let me proceed step by step, starting with the mandate I was given in this case. It is important to recall, and for everyone who may be watching and listening to these proceedings in Uganda, that my role, and here I quote from Pre-Trial Chamber 2's initial instruction to the registry and my letter of appointment, is to represent the rights and interests of Mr. Kony. But this is a paradoxical mandate to try to fulfill in the absence of any instructions from Joseph Kony about how to respond to the prosecution's case at confirmation. And to be absolutely clear, no instructions have been received by me. Our paramount obligation in this situation is to identify, to the extent that we can, Joseph Kony's interests and do nothing whatsoever to prejudice them. The pre-trial chamber, when it examined the admissibility of this case in 2009, said that any appointed counsel should not prejudice the arguments which the defence may put forward at a later stage. And the appeals chamber then confirmed that appointed counsel's mandate is to offer submissions with a view to safeguarding the interests of the suspect insofar as counsel can identify them. So my mandate is not to act as an amicus curiae, offering disinterested advice on how the prosecution can remedy deficiencies in its case, nor am I here as some devil's advocate to offer criticism of the prosecution case based on hypothetical assumptions about what Joseph Kony's ultimate position may be. On the contrary, my role is to ensure that Joseph Kony and any counsel that he may subsequently retain to represent him holds the greatest possible latitude to make arguments in relation to the prosecution's case. So you will not be hearing today about the ways in which some of the charges in the amended document containing the charges are legally incoherent or incompatible. You will not be hearing about the serious unreliability of some of the prosecution's central evidence. You will not be hearing about other ways in which the facts have been characterized by the prosecution in a legally erroneous manner. And let me say on this point, there is no shortage of issues in this case that a duly instructed counsel would love to challenge. As a lawyer of over 35 years' experience, I have to say it was painful for me to sit back and not object when I heard the prosecution use such imprecise language as you heard yesterday, referring to at least thousands of victims, and then citing to a list of 204 victims in support of that proposition. Such imprecision would not be accepted in any charging document in any legal system in the world. Your Honours, it was similarly painful for me not to be able to flag the incomprehensibility of the prosecution referring to the Coelho trial judgment as though it were evidence of its propositions. This is a judgment that's currently under appeal, as his defence lawyer, counsel and Yuru could confirm to you. And it is a final judgment from a domestic war crimes tribunal in a jurisdiction that the Office of the Prosecutor deems somehow unwilling or unable to deal with the case of Joseph Kony itself. And lastly, it was very uncomfortable for me to have to sit on my hands as the prosecution presented on screen entries from logbooks as though they were the diaries of Joseph Kony itself. Madam President, Your Honours will know from your scrutiny of the evidence in this case that these logbooks are purportedly English summaries of rough notes compiled by another person who listened in to conversations in Acholi in coded language that they oftentimes didn't understand. These logbooks went through many, many links in the chain of custody. But I cannot go into any of that. That's just my personal irritation. Because simply put, in our assessment, it is not in Joseph Kony's interests to give the prosecution the opportunity to remedy the defects in its case while it still can, and attempt to make its case stronger for trial. And this is not just my interpretation. The current prosecutor himself, Karim Khan, in a 2014 article, wrote of the key risks of presenting a positive defence case at confirmation. He said that defence counsel should be mindful that if they put forward a full defence and one or more of the charges are confirmed, then the prosecution will have been given a preview of the defence's case strategy and potential evidence. With this information in hand, he said, and here I quote, the prosecution can adapt its case strategy and continue its investigations within the framework of the confirmed case with a view to countering the defence's expected case at trial. The defence's position...
Counsel, you're getting into the meat of the matter and you are speaking faster.
One wonders what the purpose is of providing these remarks in writing to the interpreters in advance, but there you go, I will slow down. The defence's position today is consistent with the interpretation of our mandate from the beginning. As your honours know, the defence also declined to accept any agreed facts in this process. Why? Because how could counsel agree to any facts on behalf of Joseph Kony in absence of his instructions? Indeed, in Entaganda, a trial chamber considered that accepting an agreed fact without adequate consultation of the person represented amounted to a potential violation of the Code of Conduct of Counsel. On the contrary, what if Joseph Kony wants to plead guilty and seek a full mitigation of sentence for this plea and cooperation, and would never have given us instructions to challenge the form of the charges or the strength of the prosecution's evidence? We simply do not know and cannot know what his position on any of this is or would be, given that we have never met or had any contact with him, directly or otherwise. Any assumptions we might make in this regard could prejudice his future position, and I cannot do that. But this does not mean we have been unable to advance Joseph Kony's interests or safeguard his rights. As you know, we have litigated the legality of the in absentia confirmation process itself, including before the appeals chamber, which means that we have contested the fact that these proceedings, in the absence of Joseph Kony, should even take place, because in our view, they are contrary to the statute of the court. We have also challenged whether there was cause to hold this process, collecting testimonials from northern Ugandan political leaders, religious leaders, traditional leaders, as well as victims' advocates, victims themselves, and members of the legal community, who have given written testimonials explaining why they think that this in absentia process is misguided, self-interested on the part of the ICC, harmful to ongoing repatriation and reconciliation efforts, and divisive to their communities. We have challenged the form of the confirmation procedure, successfully objecting to the prosecution's irregular request to call live witnesses at this confirmation hearing, for example. And we have sought to ensure that the proceedings are as public as possible, including an unsuccessful effort in respect of the prosecution's key insider evidence, which still remains out of the public eye over our objections. And we have repeatedly canvassed the prosecution to take care with the presentation of video and other images in this courtroom for public display. In each of our steps, we have been guided by our responsibility to act in Joseph Kony's interests and minimize the harm to the fairness of any subsequent trial. But again, we have been mindful of the limits imposed by the absence of instructions, the impropriety of manufacturing those instructions according to our own wishes, and the fundamental importance of avoiding causing any prejudice whatsoever to positions that Joseph Kony may later wish to advance were he ever to be arrested, including challenging the propriety of this entire proceeding. So what does it mean for this confirmation procedure? It is beyond dispute that a confirmation decision will have an impact on any subsequent trial. As the pre-trial chamber recognized, the confirmation decision sets the parameters of the case for trial and ensures that the charges are clear and not deficient in form. But, as past confirmation hearings demonstrate, the confirmation procedure is by no means simply an exercise in judicially approving the prosecution's charges with limited or no scrutiny. It is designed to be an inter partes procedure where the suspect can actively challenge the evidence presented against him. In Mburishimana, where the charges were not confirmed, the appeals chamber said it attached considerable significance to the suspect's right to challenge the evidence presented by the prosecutor and to present his or her own evidence during confirmation hearings. This reflects the view of the prosecutor Karim Khan in the 2014 essay that I mentioned earlier. He said that in terms of how defense counsel should approach a confirmation of charges hearing, the most important factor, first and foremost, is the goals and wishes of the client. And this exercise of the suspect challenging the evidence presented against him has resulted in entire cases being withdrawn, as for example in Mokum, or none of the charges being confirmed, as in the cases of Mburishimana, in the situation of the DRC, Abu Garda, in the situation of Darfur, and in relation to two cases from the situation in Kenya, Ali and Koski. Even in those cases where some charges were confirmed, the inter partes confirmation process has led to many other charges being deleted against other suspects. For example, the pre-trial chamber in Yekatom and Engaisona declined to confirm 79 out of 111 charges. That's over 70% of those brought by the prosecution, following challenges by counsel acting upon their client's instructions. In the absence of instructions, none of this inter partes scrutiny can take place, at least not in the way that it should. And the framework of Joseph Kony's trial will be established by Your Honours in his absence. Importantly, it is the responsibility of the pre-trial chamber and not the prosecution, pursuant to Regulations 52 and 53 of the regulations of the court, to ensure that any charges are sufficiently precise so as to ensure a fair trial. All of this underscores that a confirmation decision is not a mere rubber stamping exercise, Your Honours. And it will not have escaped your attention that some of the legal interpretations that the prosecution has advanced in this case are rather creative and seek to develop substantive law in new directions. Confirmation decisions bear normative weight. They are seen and cited as authoritative statements of the relevant law. But if you were to issue a decision confirming any of the charges in this case, it would come without the prosecution charges and evidence having been subjected to any effective challenge or scrutiny by the suspect, which is precisely the reason that the drafters included a confirmation process in the first place. And this is precisely why the appeals chamber said that it attached considerable significance to the suspect's ability to challenge the evidence at confirmation. This is the very real, very concrete, and potentially irrevocable prejudice that arises from this in absentia procedure. But there is a way that this prejudice can be avoided. We all know that Joseph Kony cannot be put on trial in his absence, as Your Honour emphasised during the opening of this hearing. That much is absolutely clear and undisputed from Article 63 of the Rome Statute. This means that at some point, this in absentia process must end. We cannot all just sleepwalk blindly into the trial process without conducting an illegal procedure. At some point, the procedures foreseen for the transition between the pre-trial and the trial phases in Articles 61 and 64 of the statute will have to be stopped, either by way of a conditional stay of proceedings or an adjournment sine die. Where this line in the sand is drawn, and it must be drawn, is firmly within the discretion of this honourable pre-trial chamber. Now, a chamber of the International Criminal Court has the power to stay proceedings temporarily or permanently. Established jurisprudence provides that a chamber, and that includes a pre-trial chamber, as confirmed by the appeals chamber in Lubanga decision 772, has the power, indeed the duty, to stay proceedings where the essential preconditions of a fair trial are missing. For example, an accused. The appeals chamber has also confirmed that a conditional stay of the proceedings may be the appropriate remedy where a fair trial cannot be held at the time the stay is imposed, but where the unfairness to the accused person is of such a nature that a fair trial might become possible at a later stage because of a change in the situation that led to the stay. So it can be done. As to when it should be done, we submit that the appropriate moment for such a stay or adjournment is immediately following this hearing and before any confirmation decision. There are many reasons why. Firstly, drawing the line in the sand at this point is the only way to circumvent the real and concrete prejudice of issuing a confirmation decision in the absence of any fundamental scrutiny or challenge from the suspect himself having given instructions to lawyers. Secondly, and just as importantly, a confirmation decision signals the end of the confirmation phase, which triggers a chain of events under the ICC's statutory framework, which have practical, legal, and financial consequences for the court. If this chamber were to issue a decision confirming any of the charges, Joseph Kony would move from being a suspect to being an accused under the court's legal framework, which in turn has consequences. A confirmation decision also triggers the mandatory assignment of a trial chamber under Article 61, paragraph 11, which means the case would be moving from the confirmation phase into the trial phase, but this time in the absence of the accused. Importantly, my mandate expires at the end of the confirmation phase, meaning that this absent accused would now be dealt with by a trial chamber in a situation where he is not represented by assigned counsel. As an accused, Joseph Kony would be entitled to legal representation under Article 67, paragraph 1d, so a new counsel would have to be assigned immediately at some expense to the court. And speaking of expense, with a trial chamber in place, judicial activity will continue, also at the expense of the court, and despite the fact that Joseph Kony will still be absent. Take as a useful illustration the Banda case, where Mr. Banda and his co-accused waived their right to be present at confirmation. Since the confirmation of charges decision was issued in March 2011, there have been more than 600 filings in that case. In 2014, it became clear that Mr. Banda would not be appearing for trial, and the trial date was vacated. Nonetheless, since that time, as is demonstrated by the records of the Assembly of States parties, hundreds of thousands of euros have been spent in legal costs for this cryogenically frozen case. This is because, put simply, the trial phase generates judicial activity, even where there is no expectation of a trial. If a confirmation decision were issued in this case against Joseph Kony, the court could expect a similar level of activity. Decisions can be expected on victims' participation, cooperation issues, the composition and recomposition of the relevant chamber, representation issues, and other procedural matters. We can almost certainly expect admissibility challenges, given that the authorities in Uganda have made clear their desire to try Joseph Kony domestically, should he be delivered to their custody. Status conferences will be held, again, as we saw in Banda, where 9 years after the confirmation decision was issued, the trial chamber convened a status conference in which it raised the question as to whether proceeding with a full trial in absentia was possible. All of this, Your Honours, would happen without the participation or representation of Joseph Kony, underscoring the futility of this entire process. In the meantime, like Banda, Joseph Kony would be listed on the ICC's website as someone whose case was in the trial phase, all while he had never set foot in this building. This would further raise the expectation of victim communities and require further and regular outreach by the court to try to explain this unprecedented state of affairs and allay the inevitable confusion and frustration. And having spent much of the last 12 months in the north of Uganda, we can attest that the confusion and frustration is already there and very loud, despite the excellent and best efforts of the ICC's outreach section. A confirmation decision would set a train in motion that cannot be returned to the station. This costly, uncertain, and indefinite pre-trial purgatory of an absent accused can be avoided by stopping the train from leaving the station and staying the proceedings now before a confirmation decision is issued, because once that decision has been issued, the parameters have been set for trial. So I suppose we need to deal with the situation of what happens if Mr. Kony were to be arrested after a confirmation decision were issued. In his opening remarks yesterday, the deputy prosecutor noted, in the prosecution's opinion, this hearing will advance proceedings in a tangible way, and that if the charges are confirmed, it would allow the proceedings to move rapidly to the next stage as soon as Joseph Kony is arrested and surrendered to the court. Now, the deputy prosecutor and I go back a long, long way. Indeed, we probably first met at about the same time as the arrest warrant for Joseph Kony was issued 20 years ago. So I hope he won't mind me pouring a little cold water over his admirably optimistic outlook, or some might say, wishful thinking. Seriously, who does the deputy prosecutor think will arrest Joseph Kony? And where does he think he might be arrested? In Uganda? By the Ugandan authorities? Well, if that happens, Your Honour, he ain't coming here. My team and I have met the highest legal officers and politicians in the land. We've met the Minister of Justice, the Attorney General, the Chief Justice, and the President himself, and we have been assured that if Joseph Kony is arrested in Uganda, he will not be transferred to The Hague to stand trial. And why would any sensible, mature, democratic country do that, when they had in their custody a man who could stand charged for offences spanning a period of 20 years, encompassing thousands, if not millions, of victims, including the girls who were abducted from the Aboke school in 1996? Why would they surrender him to a jurisdiction that could deal with the tiniest slither of his alleged criminal responsibility and deny the victims in their country the right to justice? Of course they wouldn't, and they won't. So that is a non-starter. If he's detained in the Central African Republic or Sudan, and anything happens to him that is detrimental to his liberty, it would again be a transfer to Uganda with the same result. And as for the optimism that the deputy prosecutor expressed about the assistance of the United States of America, I think it's fair to say that those days are long gone. But whilst we're in this world of wishful thinking, let us just enter into a little thought experiment. What would happen in the unlikely event that Joseph Kony is one day brought before this court? If a confirmation decision were issued following this hearing, it would have been issued as a result of a situation where it had not been subject to his scrutiny. But let's say you go ahead and you issue a confirmation decision despite all of that. The important parameters of trial would have been set by that confirmation decision, And so a crucial question is, would he have the right to challenge the confirmation decision? Might he even be entitled to a full rerun of this entire confirmation process, this time with counsel of his choice? The rules suggest not. The key legal provision is Rule 1263 of the Rules of Procedure and Evidence, and allow me to quote it in full. When the person who has fled is subsequently arrested and the court has confirmed the charges upon which the prosecutor intends to pursue the trial, the person charged shall be committed to the trial chamber established under Article 61, paragraph 11. The person charged may request in writing that the trial chamber refer issues to the pre-trial chamber that are necessary for the chamber's effective and fair functioning in accordance with Article 64, paragraph 4. Now, a few things about this provision. First, it will not have escaped your attention that it refers only to a person who has fled. As we all know, and as has been the subject of extensive litigation in this case since 2023, Joseph Kony is deemed to be a person who cannot be found, not a person who has fled under Article 61. So there's a lacuna in relation to what happens to the person who cannot be found, who is not mentioned in this provision. This means that there are three options. The trial chamber could find that the person who could not be found is entitled to a complete new confirmation process from the start. Or it could hold that Rule 126, paragraph 3 applies mutatis mutandis to that person, allowing a limited referral of some issues back to the pre-trial chamber. Or it might simply hold that the case should proceed directly to trial on the basis of the confirmation decision. If the first option were to be followed, and the rules were found to allow for a new confirmation process, then the court would be required to quash your Honour's confirmation decision, because it was issued in the absence of any meaningful inter partes process. This would mean a huge waste of effort and resources, undoubtedly raising further confusion and further questions as to the point of this entire process. Should the second or third options be followed, and Rule 126, paragraph 3 were found not to allow a full new confirmation process if the suspect appears, this interpretation would be in apparent contravention of well-established human rights case law, and therefore Article 21, paragraph 3 of the statute, under which the right to de novo proceedings is fundamental. Indeed, the Special Tribunal for Lebanon's Appeals Chamber confirmed that the right to a retrial applies to all stages of the proceedings. This leads me to my second point about Rule 126, paragraph 3, which is that the least that can be said about it is that it does not confer an automatic right to reopen the formulation of charges for the person who has fled. On the contrary, Rule 126.3 appears to impose a heavy burden on the accused, as he then would be, for a referral of issues back to the pre-trial chamber, and without any obligation on the pre-trial chamber to reconsider the scope or nature of the charges. So again, Your Honours, if this pre-trial chamber were to issue a confirmation decision, it risks causing irreparable prejudice to the rights of the suspect or the rights of the accused, as he would be thereafter. Again, the solution here is to draw a line in the sand after this week's hearing. Your Honours, indeed, all that was ever requested of you in this case was a hearing of the confirmation of charges. The original request of the prosecution, filing 446, states, the prosecution respectfully requests the pre-trial chamber to hold a hearing on the confirmation of charges against Joseph Kony in his absence. In decision 466 of the 23rd of November 2023, the pre-trial chamber found that, under the prevailing circumstances, there is cause to hold a confirmation hearing against Mr. Kony in his absence. And in authorising that hearing, the pre-trial chamber said at paragraph 70, the statute does not allow proceedings in absentia to be held beyond the confirmation of charges hearing. Not decision, hearing. Now, reasonable minds may differ as to whether the purported purpose of this hearing, as stated by the prosecution, to air the evidence, to allow the victims to speak, to increase public awareness and potentially to galvanise cooperative efforts to bring fugitives to justice, were ever achievable. But one thing is clear. These purposes do not require a confirmation decision. Exercising the Chamber's inherent power to impose a conditional stay of proceedings at the end of this confirmation hearing, which can immediately be lifted if Joseph Kony is ever transferred to the court, would circumvent the many legal, procedural, and financial headaches I have just outlined that a confirmation decision would trigger. Looking at the bigger picture, compromising the rights of suspects through issuing confirmation of charges decisions without any participation of those suspects should not be the future of ICC proceedings. Far from galvanizing support for the court, such a decision would only give fuel to the fire of its detractors who wish to portray this institution as illegitimate. It is not, Your Honours, and the best way for you to demonstrate that would be to follow the precedent set in Lubanga and in numerous other cases before this court by exercising your inherent jurisdiction to impose a conditional stay of proceedings at the end of this hearing, which can be lifted if Joseph Kony ever appears before it. Thank you.
Thank you, Counsel. All right, it's 1:45. We are not behind time. The prosecution has 30 minutes, I believe, for its final submissions.
I'm sorry. Can I speak, Your Honor? Or?
Yes?
Yeah. So since we are 15 minutes to lunchtime, I would request to begin my final observations after lunch, if possible, and we could perhaps come back a bit earlier from the lunch break, maybe at 2:15, after 2, 2:15, sorry.
That seems acceptable. Yes, all right, so
Thank
we
you.
will take the lunch break from now. Give me one moment, please. All right, so we will take the lunch break from now for 90 minutes. So we will come back at 2:15.
All rise. We are on the way.